All right, so here we go. Section 107. Now, this is what Bachata Intimate was talking about, fair use. All right, this is now we get into it, y'all. It says fair use, notwithstanding the provisions of section 106 and 106A, right? Now that deals with specifically copyrights. Now this section 107 deals with fair use. It says the fair use of a copyrighted work. In this case, it will be Kevin Samuels' video that we use, which was his advice to Jessica, aka Miss Average at Best. That's the video that we was analyzing to see whether she has a valid claim of privacy violation or violation of her privacy. All right. Right. Now it says including such use by reproductions in copies or phono records or by any other means specified by the section. So that would include that does include a digital video such as Kevin's. It says for purposes such as criticism, comment. Now again, remember when I read that first definition in Google, they didn't say anything about comment. All right, they didn't say that. You noticed that too, right, Rodney?
I did.
And I told everyone, I said, comment is a part of it. And if you look at our slogan, right, our notice that we put in all of our videos, we tell everyone, right, that here at the Power of Offense, we entertain you with legal commentary. You know, comment, commentary, right? From a layman's point of view. So that's how we entertain everyone, right? Now,
right.
It says news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright, right? So the fact that we're giving commentary. All right, let me read it from the top. It says notwithstanding, right? Now we're reading the limitations on exclusive rights, fair use. That's what's highlighted. And it says notwithstanding the provisions of section 106 and 106A, the fair use of a copyrighted work, including such use by reproduction in copies or phono records or by any other means specified by that section for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include. So there are four factors that's right there, four factors, right, that shall be considered, and all of them must be considered in order for fair use to exist, right? So we already established that what we do here at the Power of Offense is commentary, as in commentary. So when we reviewed that video, Kevin Samuels' video, when he's giving Jessica advice, right, the same video that he's being sued over, we were giving commentary, as in comment on that video. All right, so we establishing that. So just right there, you know what I'm saying, Rodney?
Yep.
We were commenting on it. So now we need to look at the four factors. Now the first factor, it says number one, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. Number two, the nature of the copyrighted work. Number three, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And number four, the effect of the use upon the potential market for or value of the copyrighted work.
Now, I just want to, you don't have to pull it up. I'm just going to say it. And if anyone want to pull it up to read it themselves, they can. The definition of commentary is an expression of opinions or offering of explanations about an event or situation, which is exactly what we did with the Kevin Samuels video. The fact that the word comment was not in Wikipedia, Keith just talked to you about primary sources. So even though it wasn't in Wikipedia, which may be what Mr. What's his name?
Bachata Intimate
may have read and read only. So that secondary source that he read is subject to the primary source, which what Keith is reading, which is the Supreme Court case of the United States of America. I just
Yes,
wanted to
indeed.
lay that out. So we're using a primary source, the Supreme Court, to support our position, versus a potential secondary source, Wikipedia or another piece of a source that was used by Mr. Bachata.
Yes, indeed. I appreciate you dropping again another golden nugget on him, Rodney.
Thanks.
Commentary. Commentary.
Yeah.
But yeah, the also this is the last part of section 107 right here. I'm gonna highlight it real quick. It says the fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. So again, all of the above factors are used to determine whether the fair use doctrine applies to any particular work. Now, we can assure you here, the Power of Offense, Bachata Intimate, and all others, that our work that we did on the Kevin Samuels lawsuit, right, that we're protected under the fair use doctrine. And we're going to prove that right now. All right. Now it says
you're gonna further prove it because you just proved it. But you're going to further prove it because we like extra.
Yes, we're going to further prove. Thank you, Rodney. Thank you for the correction. It says Congress meant Section 107 to reinstate the present judicial doctrine of fair use, not to change, narrow, or enlarge it in any way, and intended that courts continue the common law tradition of fair use adjudication. It says the fair use doctrine thus permits and requires courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which the law is designed to foster. And that was cited from Stewart versus Abin, 1990. So the Supreme Court's, the Supreme Court like to cite themselves, y'all.
Yeah.
They cite previous cases. Now it says the task is not to be simplified with bright line rules for the statute like the doctrine it recognizes calls for case-by-case analysis. So whenever the courts are dealing with a fair use issue, right, it's by case, it's a case-by-case analysis. So it's all done case-by-case. This is what they're saying right there. Now, the court goes on and says right here, and I'm gonna highlight this, it says the text employs, right? And they're talking about the text in it says the text employs the terms including and such as in the preamble paragraph to indicate the illustrative and not limited function of the examples given in section 101, which thus provide only general guidance about the sorts of copying that the courts and Congress most commonly had found to be fair uses. Nor may the four statutory factors be treated in isolation one from another. All are to be explored and the results weighed together in light of the purposes of copyright.
So in other words, they're challenging the intent.
Yes.
Saying the intent behind what you're claiming to be fair use. You know what I'm saying? So That's what it's saying, and that's what it's protecting, and that's why it's case by case. You don't need all those elements, just like we discussed in one of our previous videos. Whenever you're dealing with a cause of action, you have to meet all the elements. Mm-hmm. This is telling you can just meet one of the four, but they're gonna take it case by case, and they're gonna really dive into the intent of the fair use claim versus the fair use defense.
Right. Yep. Yes, indeed. Now, right here, it says the first factor in a fair use inquiry. Now, for those who don't know, you have inquiry, which most of us are familiar with. This begins with an I, right? But you also have inquiry with an E. Look it up. Now it says that. Now I would start over. It says the first factor in a fair use inquiry is the purpose and character of the use, including whether such use is of a commercial nature or is of a nonprofit educational purposes. And then it says section 107.1. It says this factor draws on Justice Story's formulation that the nature and objects of the selections made. And then it says the inquiry here may be guided by the examples given in the preamble to section 107, looking to whether the use is for criticism or comment, Again, ours is comment, commentary, comment, commentary, comment,
Yeah.
or news reporting, and the likes. And it says see section 107. Now, the central purpose of this investigation is to see, in Justice Story's words, whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. Now, it goes on and it says, although such transformative use is not absolutely necessary for finding a fair use, the goal of copyright is to promote science and arts, and is generally furthered by the creation of transformative works. Now, let's make this clear that the work that we did, right, was transformative. And the reason why it was transformative is because we took the video, right, the infamous video where Kevin Samuels was giving Jessica, aka Miss Average at Best, advice. The same video that he's being sued upon. We took that video, right, and we gave our analysis, right, which in turn is legal commentary from a layman's point of view, meaning our unskilled at law point of view, right? We gave our analysis of whether we believe Jessica has a valid claim, right? A valid cause of action, whether it exists, right? Being a violation of her privacy. So right there, that's transformative. We created a new work based upon Kevin's work. That's what we did.
Right.
That's what we did. That's protected under fair use. That's the first factor. So is the work transformative? Yes, it is. We can agree to this, can't we, Rodney?
Absolutely.
And I'm pretty sure, but Child of Intimate, I'm sure you have to agree to it also. That our work was transformative. We weren't on there giving advice. No, we weren't. That's what Kevin did.
Opinion.
We were giving our opinion based upon the interaction between Jessica and Kevin Samuels. Whether we saw, in our opinion, that she had a valid claim for her privacy being violated. That's simply put what it was. Now let's move on. Now right here, it says, such works, right, does lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright. And it says, and the more transformative the new work, the less will be the significance of other factors like commercialism that may weigh against a finding of fair use. So again, our work is completely transformative. Completely. Yeah. And this is, and what the court just said right there, this is the most significant factor that they look at. Was this transformative? Yes, it was. We didn't supersede what Kevin did. We weren't giving advice. You know what I'm saying, right? We weren't giving dating, relationship advice. No, we weren't. We were giving our commentary based upon our analysis of Kevin's interaction with Jessica to see whether she had a valid claim, right, for a violation of her privacy. Now we're going to skip this next paragraph, all right? Because the next paragraph is talking about parody. We're not dealing with that. We're dealing with comment, as in commentary, right? But we just want to make sure we take all of the important elements from this concerning the fair use doctrine. So we don't have to go into the Two Live Crew situation for us to do that, not completely. You know what I'm saying?
No, we don't. I think we pretty much made our point.
Well, I want to go through the other three factors too. Yeah, I want to go through the other because I don't want but Child of Intimate or anyone to try to say, well, yeah, they were right, but thus far, but they didn't finish. You know what I'm saying, Rodney?
Right.
So right here it says the second statutory factor, the nature of the copyrighted work, and this is section 107.2, draws on Justice Story's expression, the value of the materials used. This factor calls for recognition that some works are closer to the core of intended copyright protection than others, with the consequence that fair use is more difficult to establish when the former works are copied. And then it goes on, it says contrasting fictional short stories with factual works, contrasting soon to be published memoir with published speech. And then it says contrasting motion pictures with new broadcasts and contrasting creative works with bare factual compilations. Now, right here, I'm gonna highlight this. It says, we agree with both the district court and the court of appeals that Orbison's original creative expression for public dissemination falls within the core of the copyright's protective purposes. It then says this fact, however, is not much help in this case or even likely to help much in separating, fair use sheep from the infringing goats in a parody case, since parodies almost invariably copy publicly known expressive works. All right, so again, the value of the materials used, right? So the values of the materials used would be, if I'm not mistaken, let me see something real quick. All right. Basically what I'm trying to say is this. Again, we passed factor number 2 because our work, right, is quite different, and it's not even close to the original work. The original work, again, is Kevin Samuel's advice to Jessica, aka Miss Average at Best, and that was an advice that he gave her. So that video was predicated upon his advice on dating and her image, right? The work that we did based upon his work was an analysis of the video to see whether, right, she had a legitimate claim for a violation of her privacy. So the way that our work, in contrast to his work, right? Our work is an analysis and is commentary on the facts in that video, right? To make a determination. And his work is advice. So it's totally contrast, totally different. So we definitely passed factor number 2. Now, factor number 3, it says the third factor asks whether the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and this is from section 107.3. And then it says, or in Justice Story's words, the quantity and value of the materials used are reasonable in relation to the purpose of the copying. Here, attention turns to the persuasiveness of the parodist's justification for the particular copying done, and the inquiry will harken back to the first of the statutory factors. For, as in prior cases, we recognize that the extent of permissible copying varies with the purpose and character of the use. Now, I'm gonna stop right there because let's make it clear, since we're dealing with quantity, right? We use. Now, I'm not sure if you noticed, but Child to Intimate, because you may not have seen the full video, but the full video that we published in reference to this particular, that particular video of advice between Kevin Samuels and Jessica, aka Miss Average at Best, right, was 1 hour and 45 minutes. Now, we took a 20-minute video clip from Kevin Samuels where he's giving Jessica advice, and we put in that video, his 20-minute video is within our video of 1 hour and 45 minutes. So we have a whole hour and 20 minutes of analyzing what we saw
within that 20 minutes.
Yes. So again, we would definitely pass this portion. Technically, we didn't even use much of his work, but we had to use his work in order for our audience to
get a full understanding.
Yes, of our analysis. Yes. So let's keep going, and we're going to read this 4th factor. Now, here we go. 4th factor. It says the 4th factor use. Sorry about that. It says The fourth fair use factor is the effect of the use upon the potential market for the value of the copyrighted work. And this is from section 107.4. It requires courts to consider not only the extent of market harm caused by the particular actions of the alleged infringer, but also whether unrestricted and widespread conduct of the sort engaged in by the defendant will result in a substantially adverse impact on the potential market for the original. All right. And it says the inquiry must take account not only of the harm to the original, but also to the harm to the market for derivative works. Now, I'm gonna stop right there and just make it clear that I don't see any way that our video, right, will harm Kevin Samuels. I don't see any way that it would.
This part right here doesn't even apply, because this fourth one is really talking about bootleggers. You ever bought a bootleg video or a bootleg tape? You buy the whole content, but it affects the market of the person's original copy work. So
right.
That doesn't apply. This is like if you used to buy up in New York, buy all those bootleg tapes or bootleg movies or bootleg when they make copies of people DVDs and tapes and sell them on the street. That's what number 4 is talking about.
Well, yeah, and that would be a superseded work.
Yeah,
you know,
and
that's not transformative.
When they start talking about market value, is how much money you're stealing from the person who originated the work.
Right, which we're not stealing anything from them.
Exactly.
But I did want to point this out, though, Rodney. I did want to point this out to you, is that I think it's right here, the first factor. Right here. Because I just want to make sure people understand clearly that all 4 of the elements or the factors are weighed against any type of fair use claim. Do you get what I'm saying?
Yeah.
Excuse me. It says Congress. Well, I want to read this real quick. It says Congress most commonly had found to be fair uses. You know what? No. Let me start right here. Let's just start probably right here. It says, nor may the 4 statutory factors be treated in isolation, one from another. All are to be explored and results weighed together in light of the purpose of copyright. That's why I wanted to make sure we covered all 4, because the court is supposed to explore all 4 of them if they're dealing with a copyright, fair use issue.
So that corrected me then, because I was saying that it wasn't like the elements of a cause of action, but this right here is the elements of the cause of action, but it's not as strenuous.
Right.
With a cause of action, if you miss one, you're done. But this right here, they're gonna weigh all of them, and then they're gonna see how each one weighed within each particular matter.
Yeah. I wanted to make sure, because I thought that's what you said earlier, but I just wanted to make sure that we cleared that up.
Yeah, that was a good look right there.
Yeah. So right here, now we just went over this case. Now again, we're not reading the whole case, y'all. We read just enough to cover fair use or the fair use doctrine. So now we know that the work that we published, right, was a commentary, meaning comment, right? We were giving commentary on a video that Kevin Samuels put out, where he was giving advice to Jessica, aka Miss Average at Best. And that particular video, Kevin is in litigation over. Jessica is suing him, saying that her privacy was violated. So what we wanted to do is see whether we can actually determine if she had a legitimate cause of action under a privacy tort. That was the purpose of us doing that particular video. So we're going to take everything that we just went over, right? And I actually pulled this from copyright.gov, which kind of simplified it. You know what I'm saying, Rodney? Now you could go to copyright.gov, y'all, and you can find information specifically on fair use.
But this is a secondary source.
Right. Well, copyright.
This is a secondary source.
I say this. I think this is the best, because we got to explain why you're saying it, Rodney.
Yeah.
Copyright.gov is a primary source. It is, because it's a government source, but it's a secondary source to the federal Supreme Court, which had the duty to interpret the copyright law, including the fair use doctrine, for the executive branch, of which the copyright.gov exists on, so that they know the proper way to operate. Did I explain that right? Oh, good, right?
Yeah, yeah.
That's basically why you're saying that.
Yeah, exactly. Yeah.
Right. Now, when it comes to like when we first looked at the definition, I think this is right here. When we first looked up this definition of fair use, and this came from I believe this came from google.com, but I believe they're pulling it from Oxford right here. Definitions from Oxford language. I believe this is where they're pulling it from. This is a secondary source. So in comparison to this definition on your screen, everyone, copyright.gov will be a primary source. But
right.
But in comparison from copyright.gov to the federal Supreme Court, this case from the federal Supreme Court would take precedence over what copyright.gov is saying. That's what Rodney is basically saying.
And I have no doubt that the copyright.gov got its information from those old case laws back in the 1800s.
Right, exactly.
The Copyright Act was created in 1976. It just explained it in the case that you just read, where the Copyright Act came from. Hence, the copyright.gov is part of that. So it is giving you like a chain of title.
Yep, exactly. And this is the United States Copyright Office. Now, to me, this will be the best thing for everyone to read, especially starting off. Judge language, or the King's language, which is the language of law, can be challenging for newbies. It can. Yeah. You know what I mean? To me, I think copyright.gov actually explains it in a much simpler way, and they're generally saying the same thing. But the importance of what Rodney just pointed out concerning the federal Supreme Court case law taking precedence even over copyright, or the United States Copyright Office, is that sometimes, because we have seen this before, sometimes the Copyright Office may have something wrong on their website, right, or be missing something that's in the case. This is why it's a good practice to go back to the case and read case law.
Exactly.
So that's basically what you're trying to relay. Am I right, Rodney?
The same thing with the definition. The definition didn't have comment.
Yeah, it didn't have comment. Exactly.
You know, so we had to go to the source so we can get all that entails with the definition of fair use, and then express it by and through the case law.
Exactly. So yeah, I think this is an easy way. Again, it says the same thing. It talks about the commercial nature, nonprofit. It basically everything we just covered. There's no point in us reading this, but I just wanted to show this to everyone. If they have any questions, and let's say they're intimidated by reading the case law, you can go on copyright.gov and read this short write-up on fair use. So I definitely wanted to say that.